Hello everyone. Today, we Group 2 would like to talk about Chapter 8, Extent of Ownership and Enjoyment. I'm Choi, and let's get through introduction. So, the control over private land ownership is actually regulated by various other legislation. And first of all, of course, land ownership is regulated by the state authority. Next, there are also Local Government Act, Town and Country Planning Act, Street Drainage and Building Act, Uniform Building Bylaws, Land Acquisition Act, and many more other statutes such as National Land Code. So the National Land Code provides two types of rights for landowners, which is paramount rights and also subsidiary rights. For paramount rights, Section 44 provided that the landowner has the right to airspace, right to the surface below, right to support of land, and also right of access to foreshore, river, or public space. On the other hand, subsidiary rights are provided under Section 45 of National Land Code, which is the right to extract, move, or use rock material, or right to fell, clear, and destroy, or use forest produce. So, first of all, let's see what is right to airspace. Under Section 44, Subsection 1, Subsection A of National Land Code, an owner has the exclusive use and enjoyment of so much of the column of airspace above the surface of the land, and so much of the land below that surface as is reasonably necessary to the lawful use and enjoyment of the land. So meaning to say, when it comes to land ownership, there are two types of requirement to be considered, which is that enjoyment must be necessary, and second, it must be lawful. Here we have Latin maxim which read as Quis est solum ius est isque et colum et ad inferos, which means whose is the soil, he is also that which is above and below. In other words, whoever owns the surface of the earth also owns the entire airspace above it. Let's move on to the next part.
Assalamualaikum and hi to Madam Bella. So this is Audi speaking, and today I will be continuing my part of presentation. So what I have here is the case of Thomas Von Lemon against Walter Webb. So this case is about the appellant and the respondent. They were neighboring landowners, and one day branches from the appellant's trees overhung into the respondent's garden. So what happened is the respondent began cutting down the branches from within his garden, and the appellant sued, arguing that the respondent was not allowed to cut the branches. So in this situation, we can identify that the issue was the respondent entitled to cut down the overhanging branches. So it was held that the House of Lords were in favor of the respondent. This is because the overhanging branches were nuisance. The respondent was entitled to cut down the branches. So the key take from this case is that we know that a person has the right to take action on their own land to abate a nuisance coming from another. So there's no need for that person to give the other landowner notice of his actions. Next, we have the case of Karupanan against Balak Rishnan. So this is specifically about aesthetical protrusions from a building. So this is actually a Malaysian case, a Malaysian legal case involving a land dispute. So the plaintiff claimed ownership of a piece of land to adverse possession, asserting that he occupied and improved it for a significant period. So the defendant disputed Karupanan's claim, stating that he possessed the original title to the land. So from this case, the issues are quite simple. We want to identify whether the appellant has legal right to encroach into the respondent's airspace. And the decision made was the court held that the plaintiff, Karupanan, had acquired ownership rights to the disputed land through adverse possession. Okay, now let's jump to the restrictions. Okay, so we know that the first things first when it comes to airspace restrictions, there's no specific provision, but it can be subject to any other written law. For example, the Civil Aviation Act 1969. And next, the necessity of balancing private and public rights. And lastly, the use of airspace must be reasonable for its legal use and enjoyment. That's all from me. Thank you.
Good day to Madam and all my fellow friends here. So hi guys, my name is JJ. Will be one of the presenter here, and also thanks for explanation from the previous presenter. So rights to underground land, so also known as rights below the surface. So the provision fall under the element is National Land Code, Section 44, Clause 1, Paragraph B. It stated that the landowner has the rights to enjoy of the land below the surface and also has the right to sue and exclude the trespasser. To know about more, so let us move on to the case law. So for the case law, there are two case law for under this situation, and both case law has liable to trespass due to the interference of the land. So as you can see, the landowner has the right to sue and exclude the trespasser. So moving on, there are few restrictions and the provision for under this situation will be the Section 92, Clause B. Is stated that the state authority has the right to depth up the surface of the land. The case law also says that you need to get the consent by the state authority. So moving on to the section 92, clause D is stated that the proprietor has the rights for the underground for personal use. And also another restriction is the section 45 clause 2 stated that landowner may not use and extract the metal and the mineral from his land. Also another is referred to case law. The case law states that this situation is not liable due to the rocks material within the section 5, the National Land Code. Moving on is the antiquity. So antiquity, what is the definition of antiquity? You can refer to the National Heritage Act 2005 section 2 clause 1. And also moving on, you need to focus on the provision. So the provision for under Section Heritage Act 47 is said that the person who finds the antiquity must notify the commissioner of the national heritage. So also, if you don't do so, here's the punishment. Is fine not exceeding 5,000 or prison not exceeding 5 years or both. So that's all for me. Thanks for listening, and I will pass it to the next presenter to continue the presentation.
Thank you to the previous presenter. I'm going to present right now for treasure trove. So to explain what is treasure trove, we have a plain explanation, which is treasure trove are valuables that are hidden in the land and under the sea. So it's hidden behind them. Therefore, right now we will move to a bit of more explanation of the statute of it. So according to Section 2 of the National Heritage Act 2005, mentioned that any money, coins, gold, silver, plate, jewelries or precious stone or any objects or any articles that value found hidden in any soil or river or sea, owner that is unknown cannot be found, is considered as the tangible cultural heritage. So to have a brief explanation is, can the finder of the treasure, can he keep it? So there is no. Because according to Section 74 to 77 of the National Heritage Act 2005, provided procedure to handle it to the Commissioner of the National Heritage at the nearest district office, or the DO, basically daerah office, daerah pejabat daerah of tanah. So an inquiry will be held, at which point the claimants of the treasure trove will appear at the district officer with inquiry of the matter. So who owns the ownerless treasure trove depends by the DO and the state government to decide whether the product that they found at the below the land or the sea is decided by who. So to reward the finder, yes. So to reward the finder, according to Section 79 of the Heritage Act, the state authority must pay a discretionary amount or sum to the finder, and offences to not deliver it is under Section 81 of the National Heritage Act. Offence level punishable by fine, maximum 50,000 and imprisonment of 5 years or both. Basically, in order of all, treasure trove is also one of the important elements in the land law. Therefore, we must is guarded by the National Heritage Act 2005 and also the National Land Code. Thank you very much. I will proceed to the next person about the rights to support.
Assalamualaikum, madam. My name is Rizwan Arif. I am going to present on the right of support, and I'm going to jump straight into what it means under Section 34.1. The provision is here. I'm just going to elaborate a little bit, which means that this provision is mentioning about a person's body, or not body, any persons or bodies, or basically anybody who can own a land, and in that style, whether in that time, in respect to any sort of land granted towards them, right? That's exactly what I mean. And in clause B, paragraph B, the right to support land in natural state is very important, and I will mention why, because the next page, this one, it just mentions on why is natural state always important, because natural state is in its essence, in my own words, whereby in the case of Angus v. Dalton, which is a principle which I will mention, actually means that in that case, basically the natural state is where the land is on its own in its back. So here we can see that the points where landowner contribution natural support from the land from the neighbour plays a very big role. So the case where basically a pond was occupied in 1954, this one was collapsed due to some mining operations, causing the flood and mining of the subsection, which also held by the park conclusion. In the sense, there was no evidence to prove that the family had any conflict with the neighbouring occupants. The claim was based on negligence, was unsuccessful. But as you can see, there are points where the miners and offenders had filed for more and more returns, or they wanted to have more support. And going on and on into this case, basically, as you can see, number 6, there is successful claims and damages for the withdrawal of support from the dominant land, because basically two things need to be proven here. The first is that the withdrawal was caused by the person being sued, and second, the dominant land was in its original natural state, because it's supported the pond and the miners, or in that land, its natural state in its essence, whether it was a pond before that, it was natural, and the miners also there naturally. So that is all from me. This is my last slide to show that this basically is what I can say here, is that the right of support imposes negative obligation, but it can also be a positive obligation in the sense where sometimes in the cases of Dalton with but Angus v. Dalton, it could also mean that something on its own as a natural state is of its essence.
My name is Janice Mizulaka, and I seabed. So foreshore refers to the highest watermark and the seabed, and seabed means the floor of the sea. So Section 44, Section 1C, landowners have a right to access the land abutting the foreshore, rivers or public places. And Section 46(1) regarding the submergence of the sea, which any part of the land affected by the encroachment from the sea of a river shall revert to the authority. So next slide is becoming state land, which refers to the Section 49 of National Land Code that states if the shoreline or riverbed advances and encroaches on alienated land, the encroached area becomes the state land. And before the year of 1966, which means that accretion principle does not apply yet in Malaysia, can be overcome by resurveying, which it can change land boundaries and become permanent, and also resurveying can reduce land area owned without compensation. So next slide is, it shows in the case of Rising Tambaram Chetia, which means that the land in question was initially next to the sea in 1935. So it's about the sea started to approaching and submerging the land around 1933, but gradually the sea began to retreat. So the applicants claimed the land to be property of the Crown, but the collector denied it and sought an order of certiorari, which is to resurvey the land, and the court held that if the land gradually and imperceptibly covered by the sea subsequently becomes high and dry due to the gradual recession of the water, then only the owner is entitled to regain the possession of it again. So that's all from us. Thank you.